Okay, so good morning, everyone. Greetings. I think we should start the webinar now. Okay, welcome and thank you for the participation in this morning webinar. Okay, my name is Liza and I will be the moderator of this webinar of ADCO's Legal Update Series. So, yeah, we have 3 speakers that will deliver this material and will join us this morning. The first one is related to potential dispute under construction contract. It would be presented by Bapak Dendi Adisuryo. Thank you, Pa, for your time. Followed by Mr. Rohit Singhal from Masin Private Limited, and he will be speaking about delay analysis on construction dispute risk. And lastly, it will be presented by Bapak Andi Satya related to how to practical approach to mitigate dispute risk. So without further ado, I think Pak Dendi would start the presentation right now. Okay, time is yours, Pak Dendi.
Yeah, right. Thanks, Lisa, for the nice introductions and moderating us. And also, I'd like to thank to Pak Andi and Mr. Rohit for joining us in this webinar. So I hope you both can share us your expertise in the international construction dispute, so it can be enrich our experience and also knowledge of all of the participants. Maybe I need a help, yeah, for the moderators to share the screen. Yeah, we have almost 100 participants right now, but maybe the one who coming already now in the room is still less than 100. But let's start it now, and then maybe along the way we can have all the participants on. So in the next 30 minutes, I will discuss about the potential dispute under common construction contract. But if I talk only the potential dispute, maybe it can be done only within 5 or 10 minutes, because I believe most of you here are the practitioners in the construction. So maybe I'll go a bit further, not only the potential dispute, but I will also discuss about the practical approach on how, as a lawyer from a legal perspective, handling the potential dispute in the constructions. The next slide. So by way of introductions, I'm Dendi. I'm a partner in Adisuryo Co. ADCO. We were established back on 2008. We are focusing on the legal services. Yeah, actually we are a full service company, but most of the works are coming from the energy and major project side, especially on the infrastructure, mining, and energy. Next. Okay, next. Yeah. Before we go deeper about the constructions dispute, I want to share you a couple of numbers. Yeah. The first is I got from the Indonesian government that the expected constructions project value in Indonesia for 2020 alone is about 168 trillions. So even though that we have now pandemic economic realizations, but there will be an increase, it is anticipated by the government, for almost 30 trillion. And it is not including the public infrastructure. Yeah, it's not including the power, it's not including the toll road, it's not including the rapid transportations. Yeah, it's only for the hotel, for the offices, the retail, educations, health, and industrial facility. So there will be a significant increase. It's almost 10% increase for 2020. And also about the contributions to the national GDP in 2019, the contribution is more than 10%. The contribution is almost 11%. It's 10 point something percent. Is the fourth highest industry contributing to the Indonesian GDP. It's based on the data we obtained from the BPS for the Indonesian statistic. Yeah, and but somehow from 2014 until 2019, there are 1,600 cases in BANI. BANI is the Indonesian arbitrations body, and 35% of the dispute in BANI are about the constructions dispute, about the construction projects. So this number shows us actually that the constructions, as always, yeah, play a very significant role for the national economic, but at the same time, it is a fragile arrangement. Yeah, it seems from the number of the dispute in the arbitration is more than 35% of from the whole case in BANI are coming from the constructions industry. Next. Yeah, these are the six most disputed. Yeah, this is the six most disputed area in the construction. Of course, you can dig deeper and add a longer list of what are the potential dispute. But at least from our observation, these are the six most frequently disputed aspect, yeah, in the constructions. The first is about the project-related matters. Yeah, it can be design failure, it can be different materials, yeah, unforeseen condition of the site, quality of the work, yeah, a parameter, consumable, yeah. And the second is scope of work. When we talk about scope of work, of course, we are talking about change order, yeah, change order in opposed of the variations, yeah. Change of order usually proposed by the project owner, or variations, yeah, usually proposed by the contractors. And next, on the schedule, on the time frame, delay, and all the consequences about the delay, yeah, whether the contractor is entitled for the EOT, the extension of time, or the contractor will have to pay the penalty, delay penalty, yeah, LD penalty, or that the project owner will have to pay compensations because the delay is contributed from the default by the project owner side. Yeah. And the next is force majeure. I think it's very now it's very relevant. Yeah, if we are talking about the project, the force majeure. Yeah, if we are talking the dispute coming from force majeure, the main focus will be on the definition of the force majeure, whether it is absolute force majeure or relative force majeure. Yeah, because if we are talking about the force majeure event, it's not only for the constructions, yeah, but also for other industry. Yeah? So we are talking about the impracticability, yeah, the unprofitability, and the impossibility. What does it mean? So FM means that it is still profitable, it is still impossible, but it is impracticable. Yeah, or it is practicable, it's still possible to do that. But if the contractor decide to continue to perform the works, then the cost will be increased significantly, and then they will lose the project. Unprofitability. Or the third is impossibility. So instead of impracticability, unprofitability, it is just impossible to do the work. Like what we have here or in other countries, in India, in Singapore, lockdown due to COVID-19 pandemic. So it's just impossible for certain construction site to proceed with the works. So it depends on what is the definitions that both parties agree in the force majeure. In Indonesia, force majeure is driven mostly by the contract, yeah, because the definition of force majeure in Indonesia is not very clear, yeah. It can be absolute, can be relative, but mostly driven by the understanding in the contract itself. The next area is on the claim and payment punctuality, yeah, disbursement of any kind of guarantee, being advance payment guarantee or performance guarantee, whether advance payment is conditional guarantee or is unconditional. Yeah, what are the requirements? And the last thing is on the external factor. Yeah, economic situations like what we have right now, economic crisis, hardship event, or social event. Yeah, for some reason, the access to the project site is blocked by the local community, and that also can drag on some delay or dispute. Next. And yeah, before we discuss about what are the dispute, and the next session is what are actually the claim, yeah, in the constructions. If we are talking in a normal dispute, then mostly on only compensation or additional cost or loss. But in construction dispute, these are the common claims. Yeah, common claims mean the actual demand, the actual claim that's solved by the party through the litigations. We have here extension of time. Extension of time, or we usually call it by EOT, is a delay time which could not be reasonably foreseen at the time of the contract is signed. The granting of the EOT will relieve the contract from the LD penalty, for example, yeah, because the delay in the delivering the work on time. The next is loss and expenses. It is the term that used to describe the additional costs incurred by the contractor as a result of the disturbance to the regular progress of the works because of matters either within the employer's control or by breach by the project owner or by the employer. The next is FO, variations order or change order. Yeah, is an alteration of the scope of work in a construction in the form of, it can be in additions, yeah, or substitution, or omission, or even omission of certain form of the original scope of the work. And then LD, liquidated damage, yeah, presented a certain legal contract as an estimate or intangible or hard to define losses. Yeah, usually we are talking about a certain percentage as an LD. Yeah. Next slide. Okay. And now source. Yeah. There are many common problems in construction dispute. Yeah, we can talk about the developer or employers. Yeah, or maybe from the consultant, the main contractor, or the subcontractors. Yeah, I think the discussion on this slide will be very lengthy, so I will just make a summary of it. Yeah, so we can save time and go more on the discussion. Yeah, for the developer, for the project owner, sometimes the mistake happen at the day one when they pick up the preferred bidder or the contract awardee, the winner of the tender, only based on the price factor. Yeah, it's simply that the cheapest tender win, the cheapest bidder wins, even if there is a mistake in the tender, even if generally underpriced, but as long as the price is okay, then price is very low, then okay, you got the works. Or unrealistic expectations. I believe there are many discussions on the topic of the construction dispute. Lawyer, contract engineer discuss and elaborate why unrealistic expectation from the project owner to the contractor can lead to the dispute between the parties. Yeah. Most of the time, I think there must be a proper composition between cost, time, and quality. If you want to press your budget, yeah, so the quality and time will suffer, of course. If you want to speed up the time, of course, the cost side and the quality may suffer. But on the other hand, also, if you want to have a very high standard of quality, then you have to be ready to have a bigger cost. So I think the expectation must take the consideration of these three combinations, yeah, between the time, the quality, and the cost. Yeah. And consultant, well, like the triangle cost, like I said before, that applies as well in the consultant, whether it's a lawyer or contract engineer or project management, yeah, and so on and so on. Sometimes the project owner only pick up the low fees, even though the resource is insufficient, yeah. Sometimes a lawyer at the same time is appointed also as the contract admin because naturally they have different skill and experience or lack of design, yeah. Next. For the main contractor, we've seen before in our experience, yeah, the contractor took the work just for the turnover, the additional turnover. They do the price war. It's happening right now. They do the price war. If it seems that the price cover all basic expenses, yeah, overhead, basic expenses, and give some extra balance, the delta between the revenue, the price, and the expenses, they will take the work and sign the agreement right away. But they don't do detailed calculations. They don't do full risk assessment. They don't do value or risk because in the constructions, all risk must be valued. There will be a price for every risk that the contractor take. Yeah. So the result is the contractor sometimes they can come up with a very competitive price, but the red line is that even the price is very competitive. Competitive means very low. They are not calculating the risk that belongs to them. So of course we can predict what will be the outcome. If something may happen, then they will just hands up. They don't look at the contract. There are too many assumptions in the agreement. Don't bother with the detail of the contract. Sometimes, yeah, they can finalize in the negotiation of a complex EPC document, for example, just within 1 or 2 weeks. That's almost impossible, yeah, even for a very experienced lawyer, very experienced construction lawyer or contract engineer. It's almost impossible to discuss and finalize the EPC only within a week. So that's the thing, yeah. Next. The other thing is the subcontractor, yeah, or NSC, nominated subcontractor. I think some of the participants may understand that or experience, yeah, that the subcontractor sometimes they are considered as a direct contractor to the employee, to the project owner, instead being an actual subcontractor. Yeah, even a party is nominated as a subcontractor, but in an actual work, they act as if that they are the main contractor. Why? Yeah, that's of course the question. Why? Can be reason that the main contractor does not fully manage and take responsibility for the subcon. Maybe because the contractor, the main contractor, has no sufficient resources. Yeah, for example, the electricity or the IT subcon. Yeah, maybe the main contractor does not have sufficient counterpart within the organizations to monitor what they are doing, what the subcon doing. Yeah, or maybe some other reason is that because the payment is directly coming from the project owner instead of from the project owner pay to the main contractor pay to the subcontractor, because there are a couple of reasons, yeah, but the most common reason is about the tax. So they want to save the VAT, they want to save the withholding tax. That's why the payment is the road of the payment is directly from the project owner to the subcontractor. Of course, the control is not main contractor, but the control sometimes comes directly from the project owner. So in some cases, we've seen this before. Yeah, the subcontractor directly communicate Q&A, a technical meeting, even take the instructions from the project owner. But once again, subcon is a subcon. Yeah, subcontractor is a subcontractor. Yeah, so the responsibility of the subcontractor in the most of constructions contract model will be absorbed by the main contractor. So doing all of these things will increase the possibility of dispute if something happens. For example, if the subcon is not performing well, for example, then which performance bond will be disbursed, whether it's performance bonds of the subcon or it will be PB from the main contractor.
Sorry, Pak Dendi, for interrupting. Yep. Your time is almost 5 minutes left.
Oh, 5 minutes left.
Yes.
Okay.
Can you wrap up the presentation?
Sure. Yeah. I think we are still halfway, but no problem. I will wrap up the explanations. Next. Yeah, then of course when we have to go to dispute. Next. Yeah, of course, like other industry. Yeah. Next, Lisa. Yeah, like other industry. Yeah. Okay, back. Okay. The most effective dispute resolution, yeah, in my view, is dispute avoidance. Yeah, maybe Bandi will explain it much better than me. As far as possible, as maximum as possible, the parties, yeah, or at least the contract, yeah, should emphasize dispute avoidance. There should be a set of clauses in the agreement that enable the party to resolve the gap understanding amicably, not directly through legal way. Of course, as a lawyer, we do the litigation for a living, but of course that's been the last resort, yeah, all the time. Next. Yeah, so just imagine, yeah, just imagine if you want to show the case to if you want to bring a case, yeah, to arbitrator or to adjudicator, yeah, just act and think like you are them. You are the arbitrator, you are judge. When they are presented with a case, what do they see? I think they'll see puzzle, yeah. They'll see puzzle. They'll see puzzle. They don't know about the project. They don't know about the personalities. They don't know about the consultant. They know nothing about the project. The judge will not know about the difficulties, the problem. They are just totally blank, yeah. Especially for the judge in Indonesian court, yeah, because unlike the arbitrator, the judge in Indonesia usually they have a general knowledge of law. Yeah, only few of them who has sense of or business technical background. So it's a bit challenging to convince them on something that is very technical. Yeah, that's why we need to make a showcase, make them understand our case, very simple, but still it must be very clear. Yeah. Next. Roadmap. Okay, so you really need to have a roadmap. For example, we've done everything we can to avoid the dispute, but then nothing's going on. We have to end it through a dispute mechanism. Then what you need to do is you really need to have a roadmap. What is the roadmap of your case? What are the issues that you need to be decided in the case? Yeah, mostly the liability and the quantum. The liability is the default point, yeah. What are the default? delay, for example, or less workmanship, output parameter, consumable, and so on and so on. That's the liability, the default part. And the quantum is the what is it? The quantum is the actual amount of the claim, and it has to be correlated. Yeah. What is it in bahasa Indonesia is sebab akibat. Yeah. Next. So we are talking about the liability. We need to review all the substantive methods. What is your entitlement based on the contract you have? Yeah. For example, I put it here as M. Yeah. Force major. Force major sometimes, most of the times, only allow the extension of time, but not money, not monetary relief. Yeah. Or procedures, whether the notifications are all done in a good order. Next. Next, okay. Quantum means the amount of our claim. So the claim, the amount of claim for each and every claim will be very specific. Yeah. For example, if you claim about the BQ is the bill of quantity, for example, you cannot combine it with a claim from FO, for example, or you cannot mix it up with the loss and expenses, LNE. Yeah. And for example, if you claim FO, yeah, variation order, you have to detail each of the FO you are claiming. You can't just put all the FOs all together, mix all these things up and come up with a final number. No, you cannot do that. So you have to make a very detail in each of FO you are claiming. But sometimes it's very challenging, yeah, splitting all the FOs or BQ is very challenging. Next. So so even we are talking not about the tort, yeah, we are talking about the default, we are talking about the one prestasi, we are not talking about the perbuatan melawan hukum, but still we have to prove the causations, yeah, the definitive correlations between the liability, between the default that committed by project owner or by the contractor and the quantum and the claim. Yeah, we have to exactly show in our documentations what would be the relationship between the liability, the default, and the loss that we've suffered. Next.
Sorry to interrupt, Dendi. Your time is almost up. Would you like to wrap up your presentation?
Yeah, maybe I will have another 3 slides. I hope I still have time just to wrap up it.
Okay, that's okay.
Yep. Okay. Yep. And these are the evidence. Yeah. So sometimes in our experience, it's a bit challenging to communicate with the engineers to help us compiling all the evidence. Yeah. So these are the 4 areas that we need to extremely prepare the evidence. Yeah, the event. Yeah, what are the damage? What are the event? The liabilities? What is the correlations? The causations? What is the impact? And what is the quantum? Sometimes we need to hire external expert. For example, like this case, sometimes we need to hire a delay analyst just to verify the event and the impact. Or we have to verify, we have to hire external just to verify the quantum that we are demanding. Yeah, as you may understand, yeah, as Indonesian legal person, yeah, under the Indonesian law, the documentary evidence plays more significant role, yeah, but not to forget other type of evidence like fact witness, expert witness, yeah, pictures. Sometimes pictures plays role. Daily notes, minutes of meeting, yeah. Next. site diary. Yeah, sometimes small contractor or small subcontractor, they don't manage site diary. Yeah, or if they do, the site diary is not detailed. Where is exactly the location of the site of the event? Yeah, for example, there is explosions like what we have in Beirut. Yeah, so the site manager, the contract engineer manager should put it on the record in a detailed manner. The location, sometimes the GPS spot. Yeah. Next, site meeting. Yeah. What will be very helpful actually is site meeting containing thorough and detailed descriptions. We have recent experience. Yeah. We represented the contractor and there was a delay. Yeah, due to access blockage because permit matters. They denied in the court documents, but when it come to cross-exam, the first thing that I cross-exam is the site minutes meeting. Are you denying that you or your PM, your project manager, has signed the minutes of meeting saying that okay, the delay is because the blockage? Most of the time they cannot deny the minutes of meeting, the site minute of meeting that they already signed. Yeah. Next. Yeah, this is if I want to make a claim, I have to compile all the facts I have. Yeah, why? What is the impact of the event? How do I show the connection between the event and the impact? Yeah, what evidence do I have to prove the event is occurred? Prove the causations. Yeah, the connections between the event and the impact. Prove the amount. Yeah, that I'm claiming. Next. Law, what is the legal basis of the claim? Whether it is contract, whether it's law, whether all the procedures under the contract already complied with. Yeah, for example, notifications. Have you submit the notifications before you submit a legal claim to court? Yeah, all the things we have to verify. Next, strategy. Wrong, weak basis is very common example. Suspension versus FM. Common issues, sometimes claimants seek advice too late. They seek advice just a day before they submit a legal claim. And they forgot that on the other day, they already make agreement or they already signed something that 100% opposite of whatever they will submit to the claim. So it doesn't help. Yeah. So you have to prepare the claim properly. Next. Claim anything you want, but entitlement, causations, evidence, defense. You have to prepare all in a very proper way. Next. So I think this will be the last slide. Yeah, if you want to go for the litigations in the constructions, that you have to set up the first strategy. The second is the roadmap, issues, yeah, evidence. In our experience, preparing evidence takes a very substantive energy and time. Yeah, evidence is not only documents. We have to start contacting the expert. We have to start to contact the engineer expert to talk with the law expert just to make everything ready just before we submit the legal claim. Sometimes evidence, we try to locate the evidence just a week before the hearing sessions discussing about the evidence. So of course, the time will not sufficient. So we have to be a very ready, yeah, just before we submit the claim to the court or to the arbitrations. Presentations of arguments and evidence and manage the dispute resolution process. So I think those are the things for the common issues or common strategy that you will have to prepare if you want to enter into litigations for the construction dispute. I think Mr. Rohit and Pak Andi you can give explorations and detailed view on the delay analysis and other things. I think back to you, Lisa. Thanks for the time.
Okay, thank you, Pak Dendi, for the presentation. It's very comprehensive. And before we go to the next speaker, I think I would like to welcome for the participation that have just joined us. And I will read the rules and agenda again before we go to the next speaker. So the webinar will be conducted for 2 hours, and each speaker will deliver for 20 or 25 minutes. I hope that we can go along with the schedule. And it will follow by the Q&A sessions after all the speakers has delivered the materials. So for the participants, are required to turn off the microphone because I found that several participants still being on mute. And then if you want to ask for this question, you can start the, you can turn on the mic after the speakers have delivered the materials on the Q&A session. So, and you can also deliver it in Bahasa Indonesia, and I would help you to translate it into English. So without further ado, I think the next material will be delivered by Mr. Rohit. Mr. Rohit, okay, the time is yours.
Thank you, Lisa. And can you stop the sharing of the screen so that I can share my screen?
Oh, okay. For operator, can you help me to stop the share screen?
Okay, so we have stopped the share screen, so you can share your screens, Mr. Rohit.
No, you have to allow me. You have to give me the control for sharing the screen.
Okay. Okay, I have made you a host, so you can share your screen.
Yeah. Good morning, everyone. It's a pleasure to be part of this webinar and to talk about construction claims and disputes. I think, Dendi, you did a wonderful job. You have set the stage to talk about what we call as delay disputes or delay claims in construction projects. My name is Rohit, and I am the Chief Executive Officer of a claim consultancy and arbitration expert firm called Masin. We are basically an international firm which is into providing consultancy. We are not lawyers, we are engineers. We provide consultancy to construction contractors, developers, employers, and the lawyers to do what we call as delay analysis and quantum analysis. As Dendi just now said, that construction disputes are very typical and complicated in nature. So a lot of time experts have to be engaged in order to give evidence and explain to the arbitrators or to the judges what are the issues related to delay. Because we are experts, we do this analysis of delay day in and day out. We do the analysis of quantum every day. So we are in a better position to explain to the arbitrators and the judges what are the intricate issues related to delay, technical matters, and quantum. My company's name is Masin. We have a local Southeast Asia office in Singapore. Besides that, we are based in Middle East and India. So the topic of my presentation today is delay. As Dendi said, amongst the common causes of construction dispute, one of the most common disputes which you will find in almost every project is delay, which means who has caused the delay? Is it the delay caused by the employer, or is it the delay caused by the contractor? And every time what you see is that both the parties, both the employer as well as the contractor, are blaming each other and saying It's not contractor, it's the employer who has caused the delay, and vice versa. Employer says, no, I as employer has not caused the delay, it is the contractor who has caused the delay. So then what happens? How do you resolve this dispute? How do you come to a conclusion that if a project has suffered 100 days of delay, who is responsible? Is it the contractor or the employer? So there what we do, what is called as a delay analysis, which is a technical method of evaluating delay claims and is very common in arbitration world, in the legal world, and the judges and arbitrators rely on delay analysis to find out the quantification and the liability for delay. So my presentation is going to be basically on 4 areas. I'll first explain you what is delay analysis, what are the typical nomenclatures used in the analysis. Then I'll tell you what are the various methods of delay analysis, how the various types of delay analysis are done. And then I'll explain to you what is the basis on choosing the methodology, which method is to be used in what circumstance. And finally, I'll give you a small slide on the quantum of the delay disputes, means prolongation cost. So if a contractor has been delayed by an employer, he suffers a loss and damage. How do you quantify that loss and damage? What are the components of that quantification? These are the 4 areas which I'm going to wrap up, in my 20-25 minutes, which are available with me. In between, I have a couple of slides which I may have to skip because of the paucity of time, but these slides can be shared by ADCO Law to all the attendees. And in case there are any questions, you can raise it towards the end of the session, the Q&A time, and I'll be more than happy to answer those questions. So now let's talk about delay claims. As I told you in the beginning, always the contractors have that feeling that they have been delayed because of reasons beyond their control, either because of the employer related reasons or because of force majeure or some third party reasons. While the employers or the owners remain unconvinced, they think that no, it is not the employer who has caused the delay, it is the contractor who has caused the delay. Therefore, contractor is not entitled for any extension of time, but is not is liable for liquidated damages, or what we call as delay damages. In a typical contract, in the region, you have a maximum cap of the liquidated damages, which is approximately 10% of the contract value. So let's say if you have a 50 or 100 million US dollar contract, you can see that 10% of that, which means $10 million, is the liquidated damages because of delay. And similarly, if a contractor has suffered delay because of employer, he has also got a huge quantum of a prolongation claim. So a delay dispute is a major dispute which has large sums of money which are hinging on the dispute, and the outcome of this and resolution of this dispute is very, very important for both the contractor and the employer. Now, what do you do in that case is, how do you resolve this? So what you do is a thorough schedule analysis is important, that who has caused the delay, is it the contractor and the employer? And it is important to resolve the delay dispute, the impact related to the disputes. Now, in case of a delay caused by the employer, what are the entitlements of the contractor? Number one, contractor will claim what we call as the prolongation cost, which means that he has spent extra money to spend extra time at the site, so he intends to claim that money. Number two, supposedly the delay caused by the employer is so much, and the contractor in turn accelerates the project and mitigates or reduces the delay. This is done by way of deploying additional resources and bringing in more people, more equipment, more manpower at site. So therefore, there is a cost involved in mobilizing these additional resources and operating and running these additional resources. Now we call those costs as acceleration cost. So how do you demonstrate whether a contractor has really mitigated the delay of the employer, or is it his own delay for which he has mobilized additional resources? You find out through what we call as the delay analysis, and this claim related to acceleration is called acceleration claim. Same way, let us assume that there is a delay caused by the employer to a contractor's work, and as a result of which the resources of the contractor are not able to produce what it was planned to produce for. Example, let's say if there is a civil project, the contractor was estimating that he will do 100-meter cube of concrete every day, but because of some delay which is attributable to employer, example, let's say if cement is a free issue item and cement is not given on time, therefore the contractor is not able to do 100 meter cube of concrete per day, but is able to do only 50 meter cube of concrete per day. In that case, the concrete batching plant is not producing 100 meter cube, but is producing 50 meter cube per day. Now, this is called a loss of productivity of the batching plant. So this claim is called loss of productivity claim, or we also call it as a disruption claim. So in order to prove that there is a disruption caused at site because of the employer reasons, you do what we call as a disruption analysis. So to conclude on this slide, it's a very critical issue in every construction dispute, and delay needs to be resolved. How do you resolve it? You resolve it what we call as the delay analysis. And that's what now my next slide is going to say. There is a very important, guideline, industry guideline, what we call as the Society of Construction Delay Protocol. So attendees, if whosoever are not aware about this guideline, can just go and Google SCL Delay Protocol. It's a February 2000, I think, 17 edition, second edition, and it is freely available on the website of Society of Construction Law. Society of Construction Law is a society of in UK, which has come out with this beautiful document called the Society of Construction Law Delay Protocol, and which is very, very commonly referred in disputes related to delays in construction projects. Now, as per the SCL protocol, Society of Construction Protocol, only the delay events which impact the critical path of the project entitles the contractor to extension of time. And it is very important to understand this concept. What we have seen many a times is that both the contractor and the employer are alleging delay on the other party. Now, without understanding and without estimating and without knowing that whether the delay which is being alleged on the other side is a critical delay or not. So it is very important to know that not all delays entitle a contractor to an extension of time. It is only the critical delays caused by the employer or other third parties which are beyond reasonable control of the contractor, which entitle the contractor to extension of time. I'll give you a very simple example, that let us assume that there is a room which is to be constructed by a construction contractor. And in this case, a room has got a roof and a room has got a couple of doors and windows. Now, let us assume the employer has delayed the drawings for the doors and windows, but parallelly the roof construction is delayed by the contractor because of the non-availability of the resources or anything. So at the time when the roof is delayed, the non-availability of the drawings or the delay in the drawings of the windows and doors by the employer is not a critical delay. It is the delay of the roof which is critical delay, which delays the end date of the project. So what is a critical delay? A delay which impacts the end date of the project. Now let us assume there is a delay of contractor and employer. It may be possible that it is only the employer delays which is critical and contractor delay is not critical. Now, how do you then find out that which of the delays are critical? That's what is done through what we call as the delay analysis. Now, another very important point which we need to understand as per SCL delay protocol, not every extension of time entitles or automatically gives entitlement to additional cost to the contractor. So let us say if tomorrow your employer, if you are a contractor and your employer grants 100 days of extension of time, that does not mean that for entire 100 days you will be entitled to additional cost. There is a concept called compensable delays, which I will explain in future slides, in further slides, which the delays which entitle to additional cost are what is called as a compensable delays, and the delays which entitle you to additional time are basically called as excusable delay. Now, the main effect of the extension of time which is granted by the employer to a contractor is that the contractor is relieved of its liability from liquidated damages, but he may not be able to get extra cost because of that extension of time unless it is proven that that extension of time has really caused loss and damage to the contractor, and that loss and damage is the sole liability, I repeat, sole liability of delay caused by the employer. So this I will be explaining more in details as I move to my next slides. Now let's talk about schedule analysis, delay analysis, also called as forensic schedule analysis. What is it? It is basically a study and investigation of the events using CPM. CPM is critical path method or other recognized schedule calculation methods for potential use in legal proceedings. To explain further, delay analysis is the study of how actual events, means delay events, interacted in the context of a complex model for the purpose of understanding the significance of a specific deviation or series of deviation from some baseline model and their role in determining the sequence of tasks within the complex network. On a very simple level, in every project, a contractor and an employer has what we call as a planned schedule, a baseline schedule. So when the project starts, a schedule is developed, and this schedule is developed either in the form of using a software called Primavera, Microsoft Project, or in an Excel sheet or in a bar chart. And then this schedule determines that how various activities are going to be done, when which activity is going to be done, what is going to be the start date and the end date of various activities, and how the project will be executed uh, within the time frame which is defined in the contract. Now, if there is a deviation from that schedule, that baseline schedule, that means that the project is getting extended. So a study of various delay events which are caused either by the employer or the contractor and their impact on the baseline schedule is basically what is called as the delay analysis. Now let's talk, before I move to the types of delay analysis and more details about delay analysis. As I explained you in my previous slide, not every delay caused by the employer entitles a contractor to an extension of time or additional cost. Only the delays which are on the critical path of the project, which are critical to the project, which cause an impact on the end date of the project, are the ones which entitle a contractor to extra time and maybe extra cost. So therefore, in our terminology, not every delay is a delay which leads to extra time and cost. Now let's see what are the various types of delays, and then we see which delay gives extra time, which delay gives extra cost to the contractor. Number one, excusable and compensable delay. Now this is the type of the delay which gives contractor extra time as well as extra cost. Now this is the delay which is caused by the employer, not attributable to the contractor, and generally it is non-concurrent delay caused by the employer. So the word non-concurrent is important, which means that there are, let us assume, two delays which are going parallel to each other, one of the employer, one of the contractor, and both of them have affected the critical path. Then these delays are called concurrent delays. Now, if there is a concurrent delay, then that does not give an entitlement for cost to the contractor. It may give additional time to the contractor. So a delay which is non-concurrent caused by the employer and has affected the critical path is what is called as a excusable compensable delay, and it gives time as well as cost. So therefore it has to be non-concurrent or sole delay caused by the employer. Then the second type of delay is excusable non-compensable. For example, let's say force majeure. As Dendi explained, in case of force majeure, a contractor is entitled to extra time, but no cost. Now this is a delay which is beyond the control of the contractor, but that comes under the category of excusable non-compensable. So it gives extra time, but no cost. So in case of a concurrent delay, when both contractor as well as an employer have caused delay to the project, and both the delays have affected the end date of the project, are on the critical path, then in such a case, this gives extra time to the contractor, but no extra cost. And these are called excusable non-compensable delays. Then the third type of delay is inexcusable delay. Now, this is a delay caused by the contractor and results in liability of the contractor for liquidated damages. Now, let's talk about various methods, how a delay analysis is done, what are the pros and cons of various methods. Now, I'll be explaining at a very higher level on the various methodologies of delay analysis. There are further slides which talks about details of the methods, but because of the paucity of the time, I'll not be able to go into the details, but I'll try to explain you on a higher level what are the various methods of doing delay analysis. Number one, a delay analysis requires a schedule. It requires a baseline schedule, or it requires what we call as a plan schedule, and it may also require what we call as the updates of that schedule, that how a plan schedule has changed as the project has progressed. And also it may require what is called as the as-built schedule, or once the project is finished, what are the actual dates on which various activities have been done, what is the actual sequence in which various activities have been completed. Therefore, in order to do a delay analysis, what is required? Number one, schedule. In case it is not there, then definitely you need the facts of the case, the facts of the delay, and the dates on which various activities, delays, events, etc. have happened. Now, there are two broad methods of delay analysis. One is called as a prospective method of delay analysis, and the second method is called retrospective method of delay analysis. The English meaning of the word prospective means looking forward. Means that today, if I'm on 18th August 2020, and I have a delay which happens today to my project, I do not know in future whether I will cause a delay to the project or not, but I have suffered today on 18th August 2020 a delay caused by the employer. So when I do a delay analysis telling the employer that Mr. Employer, I am entitled to additional 100 days because of the delay caused by you as on today, that is called as a prospective method of analysis, delay analysis. Under this prospective method of delay analysis, you have what we call as a time impact analysis and impacted as planned method of analysis. So this is looking forward. Same way, if today I say on 18th August 2020 that my project started, let's say on 1st December 2019, and from 1st December 2019 till 18th August 2020, I have suffered delay by the employer, and then I know what has happened in actual because I'm looking at the past. I know the delays of the employer. I know my own delays as a contractor as well. So therefore, when I do an analysis for the past delays, that is called as a retrospective method of analysis. Under this retrospective method of analysis, you have what we call as a as planned versus as built analysis, as built but for analysis, and there are a couple of more analyses. More details about these are available in the document which I told you, SCL delay protocol, and even there are some American guidelines called American Association of Cost Engineers recommended practice for forensic analysis. All these are available free of cost on Google and internet, and you can review find out more details about retrospective and prospective analysis. So to conclude on this slide, prospective analysis, looking forward, retrospective analysis, looking back. Looking forward, I am basically doing assumptions. I do not know in future, maybe I as a contractor might be suffering, might be causing delays. Maybe more delays may happen from the employer side. But then I say, as on today, I have a delay which has started. For example, today land was to be given by the employer. It has not been given. I give a notice to the employer, Mr. Employer, because you have not given me land, and if you do not give me land in next 30 days, I will have an extension of time entitlement for maybe another 30 days, 60 days, or whatever. That is prospective analysis. Retrospective, that in the past, land has not been given by the employer, let's say for 30 days, but in which maybe 15 days of critical delay is caused by me and it is non-concurrent, then in that case, I am entitled only for net 15 days of extension of time. So you see how situation differs. Outcome of a prospective delay analysis will be quite different from the outcome of a retrospective delay analysis. Now, I will skip these slides. So these slides basically talks about more details about those 4 or 5 methods of delay analysis which are there, but these slides can be shared with you through ADCO Law. Because of the paucity of time, I will probably skip this. And I will now go to my third category or third objective of my presentation, how to choose methodology and what should be the basis. Now, you know, as I told you, there are 4 methods. There are more methods of delay analysis. Broadly, it's a retrospective or a prospective. Now, what should be the right method? What should be the way it should be chosen when you have a dispute or you have a claim for entitlement for extension of time as a contractor? Number one, you will see what your contract asks for. Is it asking for any specific method of delay analysis? Is it asking for any specific type of delay analysis? Is it specifying something? Is it talking about that how concurrent delays have to be taken into consideration and how they have to be handled? So read the contract. Jurisdiction, for example, under Indonesian law, what is the method which is most prevalent? What type of, in what ways the law allows you to claim your cost for concurrent delays and all? That is another way by which you can find out what is the right method. You can discuss with your lawyers, and they can also share with you. Your claim consultants can also tell you, companies like us, and we can tell you what is the right method of doing the delay analysis in light of the contract and the jurisdiction. Then what information is available? So let us assume you do not have an as-built schedule. You do not have the updates of your baseline schedule. You cannot do a retrospective method of analysis, because retrospective means you need data of the historical data. You don't have that historical data, then you cannot do a retrospective analysis. If you do not have, let's say, if you do not have progress or any other details, you do not have facts, you do not have delay events. So all those things are important to understand what method of analysis is to be done. For example, you only have a baseline schedule. You know that these are the delay events. You do not have as-built data. You do not have progress updates. Then probably you will only be doing what we called as a impacted as planned method of analysis, or probably your delay expert might try to create an as-built schedule to do a as-built as planned. So the data availability is also very important. Then time and money. There are certain methods of analysis, for example, but for method of delay analysis, which is really time consuming. It takes 8 to 10 weeks or 12 weeks to do that kind of analysis. Vis-a-vis, you have an impacted as planned method of analysis, which is very fast and cost effective. And then at what stage of the project are you submitting your delay claim? Maybe you are in the beginning of the project or the middle of the project. You have not completed the entire project. So you may be only able to do part retrospective and part prospective analysis. If you are in the beginning of the project and in the beginning itself, your land has not been given or contract has not been signed or your start date of the project has got changed, you will do a prospective method of analysis. Let's say you are at the end of the project and you are in arbitration. In arbitration, prospective methods of delay analysis are not acceptable, and the arbitrators will generally accept only retrospective methods of analysis. So therefore, what is the timelines, at what stage of the project, what extent of records you have, what kind of time you have for submitting your extension of time claims also determines the method of delay analysis which you intend to choose. And then, as I said, type of the project. For example, if you have a complicated oil and gas project, minerals, mining project and all, and this is a complicated project wherein a high level as planned, as built analysis is difficult to be done, because the schedule has got hundreds and thousands of activities which are all correlated to each other. So therefore, the type of project and at what stage of the dispute also determines what is the right method of analysis. Again, the SCL protocol gives you an idea at what stage which type of method has to be used and what are the documentation which are required. Now I repeat what Dendi said. Facts are most important. Fact is the king. You have to have the facts. Record keeping is very important. If you do not have a schedule, you do not have a baseline schedule, you do not know what delays have happened, you have not notified the delays to the employer. All those things are very, very important. So it is very essential that all the documentation, records, facts, effects of that delay events, all those things are available. Then only you will be able to do what is a good delay analysis. And at the end of the day, a judge or an arbitrator will definitely look at delay analysis, but he will also look at fact. As Dendi said, if there is a minutes of meeting signed by you and you have accepted as a contractor that you have delayed the project, then that becomes an overriding document at time, as compared to a delay analyst or a delay expert saying, no, the delay is by the employer. So fact is the king, which is very important to understand. So to conclude, basically delay analysis comes in various formats. but is the most effective and important tool to resolve your delay dispute. However, facts and common sense are the king, and they are most important aspects of a delay. Just last slide. What are the constituents of a prolongation claim, a delay claim? So it is important to understand that when a contractor has suffered delay, he puts what is called as the prolongation cost claim. Now, in order for you to develop as a contractor a prolongation cost claim and an employer to review a prolongation claim, backups and actual evidences of the losses suffered by the contractor because of the delay caused by the employer are most important. And it is a very big misconception that if you as a contractor get an extension of time, you are automatically entitled for prolongation cost. No, you may have to study the jurisdiction and that how a concurrent delay, which is a parallel delay caused by the contractor to the employer project, and an employer delay running parallel and critical, how concurrent delays are going to be dealt with, how whether they are going to entitle only time or there will be a apportionment of the cost or the entire cost is to be given or no cost is to be given. Then a prolongation cost generally will contain only time related cost, how you have suffered damages and losses owing to the uh, delay caused by the employer. That's what is to be done. The direct work related resources, machinery, manpower, and all are not part of the prolongation cost. Now, this is a very intricate topic which I cannot explain right now because of the time. Maybe some other webinar we can have where I can explain you that under prolongation cost, you do not claim your resources, direct manpower, direct resources, excavators, cranes, and all that. You claim it under disruption claim. And then again, under prolongation cost, you can claim loss of head office overheads, you can claim loss of profit, you can claim loss of opportunity. So these are some of the heads of the claims which comes under the delay claims. I think that brings me to the end of my presentation, and thank you. And we have a Q&A session in the last, and I'll be more than happy to answer any question for that. Thank you.
Okay, thank you, Mr. Rohit, for the presentation. It's very on schedule, on time. And the last speaker would be Bapak Andi Satya Nugraha. Before we continue, for participant can also ask question through chat box. So after the third speaker is finished with the material, we can start with the Q&A session. Okay, Bapak Andi Satya Nugraha, time is yours to present.
Okay, so I will try to share our screens. Okay. Okay, thank you everybody. Mbak Liza, Pak Dendi, and Pak Rohit is very honor for me to participate in this a very great webinar, with great peoples and a great presentation by the previous speakers. Thank you very much for that. And my slot, my time, I will try to what we call it. To explain and to share about what is the practical situation of the dispute in the construction industry in Indonesia. So it's a little bit about me. Then I'm working as a corporate contract manager for one of a multinational European company, vendor company, and also I'm acting as an individual consultant for many contract and claim matters. So it's a little bit about me. And okay, this is very great presentation by Pak Dendi in advance that he already explained about what is the potential dispute or what is the source of dispute of the construction in Indonesia. So actually we are talking about the Indonesia now. And yeah, I just repeat that what is Pak Dendi already explained based on his experience. But I try to pick up from Bani, from Indonesia Arbitration Research, that is officially published by the research that in Indonesia, the major source of dispute in the construction industry first is inadequate and inaccurate design information. This very common practice from the employers. This is the employer default actually. And then the slow client response, this is very common also as well in Indonesia, that the client is very slow, or maybe is quite slow to approve or to to respond the drawings or some technical specification from the contractors. It will be a big delay for the contractors. It quite happens in Indonesia. And the unclear risk allocation and scope of work, yes, of course, the contract document is not telling you what is the right scope of work and what is the allocation to be, the risk to be allocated. So this is very, very common as well. And the pure communication, yes, there is no communication and record on correspondent as well. It is not quite good in place. And next is an adequate site investigation data. Yes, it's many, a lot of tender that employer just give the obsolete, let's say like site investigation is about 5 or 6, 7 years ago, which is not related to the upcoming situations. Then it is considered also as a source of the disputes. Incomplete tender information, yeah, we will talking more about this one in the next slide. And the poor contract administration process, Pak Dendi already addressed very well that the person who are in charge or appointed as a contract administrator or contract managers or contract engineers is maybe somebody from the law background, and which is not not owing or not having the skills or the knowledge about some of the construction business process or engineering business process. This is the valid source which I got from the Bani, yeah, from Bani Research for this one. And this is the what we call it, the somebody from Bani also has released the what we call it, the fact, yeah. What is the dispute, yeah? If you are employer or you are contractor, or maybe you are engineers or consultants, which is appointed by the employer, which kind or where is the states of dispute you are facing now, yeah? Let's say, but it is very not uncommon, yeah, preventive in the very beginning of the contract signing, unless you are very well-known or established company or multinational company. Yes, you have a very proper risk review process, or maybe risk management process. Yes, you can mitigate from the very beginning. But at Indonesia, we have to the next gate or next stage gate is corrective, yeah. So you have signed the contracts and you find the dispute. It is the very common, yeah, very common in Indonesia that the dispute arises before after the contract signing. Yeah, so the last one is the adaptive approach, that after contract signing and the dispute arise, and then if this maybe this the most common in Indonesia, when the dispute arise, you just knock the door of the lawyer office, or maybe a Pak Rohit office. Pak Dendi and Pak Rohit, please allow me, please help me to resolve the dispute. So I think the perspective is very, you have to, you as a practitioner from the construction industry, you must know the basic of the risk management. Yeah, how about to avoid or to minimize the dispute is in the very beginning stage of the construction stage or the construction business process. So you see in this chart, if you try to resolve your dispute in the very in the adaptive stage, let's say, the cost benefit on the value benefit to the what we call it, the dispute itself is very time consuming, and also is very is very costly. This so the basic understanding and the basic knowledge to avoid the dispute in the very beginning stage of the project is very critical now. Okay, we will yeah, this is the simple chart of the what we call it, the dispute risk avoidance, yeah, or dispute approach. So you have to identify from the beginnings, you have to avoid, mitigate, and resolve. So let's say we are talking about identifying the risk of the disputes. Yeah. Yes, this is what just what I said in the beginning, that the risk identification in the very beginning of the project is very critical. You know, in the tender stage, let's say you have to see and you have to consider the adequacy time of the tender preparation and submission. Dendi already talked about this one. A very tight tender time or duration will, you know, will produce a very poor or very not inappropriate tender proposals. And the second one is the completeness of tender documents, the correctness of tender documents, tender clarification and deviation, contract negotiation, contract document formation. This is the kind of the checklist that you have to consider in the before the contract signing. This the activity, this a risk management activity or contract risk management activity that you have to conduct. Then what is after the contract signing? Yeah, during the kickoff, during the progress report, the daily, weekly, monthly, the record is already well explained by Pak Rohit and Pak Dendi. The site instruction as well, the formal variation order, the final account quantity. So I think you have to map here. You have to get the mapping of the what is potential risk, which is contributing or maybe triggering the disputes. Then you will know the process, and you will know what is the potential risk or potential source of the dispute. You have to know. Then we are go through the avoiding the dispute. Yeah. The firstly we have identify and what is the how to avoid. Yeah. This is the very best and a very recommended practice from the to minimize the dispute, to avoid the dispute. First, you have to conduct the risk review process. Yeah, in the very initial stage, in the tender stage, you have to conduct the what we call it some risk review process. Yeah, you have to know about you have to exercise all the tender documents, and you have to see. You have to also to prepare the proper estimation cost and schedules. The program of the works, the project schedules, and also you have to what we call it adequate time to prepare and submit the tender proposal. Yes, and during the execution stage, you have to establish the intensive and proactive communications, is including the verbal and timely written notification. Yeah, during project execution stage. So Pak Dendi and Pak Rohit already well explained about this. And a good contemporaneous record keeping during the project execution stage. That's just to reinstate what is the Pak Rohit said, that at the beginning and at the end of the dispute, the judge or the arbitrator, yes, they will find or they will contest it, the facts by the contemporaneous record. Contemporaneous means the record that being created and the time that the event is occurred. So I think the site record and daily record, it is very important, and it is recommended to be signed or to be acknowledged by the both party, by employer, the contractor, and the consultants. This we'll skip this one. And how we mitigate, yeah, because after we are identifying, after we have try to mitigate and we are to avoid and we are trying to mitigate, yeah. So we as a as I know, for the big company or the multinational company, there is some good and very robust contractual affairs or contract management department that supporting all of the projects members from the end, from the tender and until the project completion or project execution. So first thing first is in the contractor side, maybe they trying to say that the back-to-back contract is a part of the risk mitigation, yeah, to pass through the risk from the, you know, if we are main contractor, to pass the risk from the employer to the subcontractors. And pay when paid, pay if paid, yeah, according to the jurisdiction where Indonesia, that the subcontractor on the third layer of the construction player or construction practitioners in the hierarchy of the projects should be guaranteed by the payment, payment from the end is from the employer. And the risk flow down scenario, I think is quite the same with the back-to-back. You have to know the what is the requirement of the warranty from the, let's say like a warranty from the main contract. What is the requirement of the time schedule? Like Pak Rohit said, from the main contract, you have to flow down to your subcontractors. And also the indemnity is a legalized terminology. Knock for knock, that you know that there should be a reciprocal indemnity, both from the employer to contractor and contractor to employers. So I think this is a part of the mitigations and the contract one clause. The insurance scenario, yes, you all know it well with this, what is the requirement for insurance in the tender document or the contract document? What is the deductible? So you have to address all of these risks to the insurance. And also, please be aware of residual risk. Then, because we are talking about risks in this webinar, in this two-day webinar, so please consider that in the risk management that there will be a residual risk. That means that the risk that cannot mitigate to the other party means that if you are an employer or you are the project owner, you cannot 100% to even your contract is lump sum or lump sum fixed price. You cannot by automatically 100% to mitigate all risk to the contractors. So in the identification risk, please be aware of how to identify the risk. And okay, to resolve, because just few slides from me, that to resolve the dispute risk, okay, Pak Dendi is already well explained about what is the forum of dispute resolution in the agreed contract. Whether it is maybe the firstly maybe amicable settlement, then we are going to the dispute adjudicators, then going to the arbitrators. So you have to know what is the contract says, because in the some of the contract in Indonesia, construction contracts, which is used by the owner of the state-owned, please be careful that they just appointed directly to the local court. So, you know that the process to the litigation in the local court is very time-consuming. So you have to be aware what is the forum is agreed by the contracting parties. That's an amicable settlement. Yes, it is like a musyawarah mufakat in the bahasa Indonesia. Adjudication, arbitration, and litigation court. Pak Dendi actually has will explain about this one. So I just want to touch about what is the current situation, what is the current trend of resolving the dispute. So if we are talking about the standard of formal construction contracts, we are talking, let's say, about the FIDIC, the newest edition, the 2017 editions, which is released on the January 2017. There will be a very significant roles, a very significant approach of trying to resolve the dispute. The firstly is the proactive approach. The FIDIC 2007 compared with the FIDIC 99 is a very lengthy. It's about 5% in the volume. Is about 50% more longer in the volumes in pages. And also they are encouraging about the proactive approach by all project members, and especially the engineers. The engineers has like a superior roles, and to trying to resolve the dispute. And also they are trying to introduce the new approach of the disputes, which is also so-called a dispute avoidance board. In FIDIC 1999, we are knowing about the dispute adjudication board, but in this edition, they are trying to introduce the dispute avoidance boards. So what is the avoidance? Means that this is like a dispute board that is appointed in the beginning of the projects that expected to resolve or to give some professional or practical advice to the project members to mitigate the risk at the very beginning of the time on the project. So it is very important because it's my my previous slide that the cost of benefit or the time consuming the time frame to resolve the dispute after the dispute arise is very costly and very timely. So why we are taking in the front end, that we are trying to mitigate the dispute in the very beginning of the project. So this is the purpose, this is the spirit of the dispute avoidance boards. Then okay, it's a little bit about the COVID. Dendi is already pointing about this one, about how we deal with maybe the COVID-19 as a force majeure is quite debatable. So, but this I just want to try to, because this is very what we call it, factual now, the impact of the COVID-19 to our projects, to our construction projects. So what is the solution advice is to have the collaborating approach, early risk identification, and the network perspective of contractual relationship. What is the network perspective of contractual relationship? Like this. Okay, so maybe in a very common way, we are just saying that we just see that the contractual relationship, or the relationship is only with employer, with contractor, yes, by contractually. But there are very a lot of party or stakeholders which is going forward carry out by the contractors as well as the employer. That employer has the end customer, and contractor also has the subcontractor, as some vendors or fabricators. So the network perspective to resolve this issue, because this is all of the contracting party is impacted by the COVID. So we are trying to resolve by the by the collaborating what we call it, the collaborating resolution, by the network perspective. So please consider this one. It's just little bit for me to avoid or to mitigate the COVID risk. So my last two slides. Okay, but okay, the last 2 months, the ARCADIS, the Global QA Solution, has released the official Global Construction Dispute Reports. That what is the most common method to resolve the dispute? This is the Global Construction Dispute Reports, by all the continents that trying to be presented by the ARCADIS team. That the party-to-party negotiation is the most common, they have the first rank of the methodology to resolve the dispute. I think this is a very appropriate with our culture in Indonesia to make some musyawarah for mufakat, the kesepakatan for the resolve the dispute other than compared with the mediation arbitration. So I think this is the facts. And what is the golden principle of party-to-party negotiation? I think we are here, and the participant is a practitioners. We know how to deal with this construction dispute. Whether in some cases or in some instances we have to go to the court or arbitration if we are facing the deadlock. But we know how is the culture to deal with the customers, how to deal with the project owner or project employers. So the rules number one is you have to know your counterpart. You have to know maybe your contractors, or you have to know what is your owners or employers, whether this is state-owned company or whether this is a private company or this is a government company. Is very you have to what we call it. You have to establish the different strategy to negotiate with this kind of different counterpart. And the second one is know your contract. Yes, Dendi and Rohit already well established about this one. Know your contractual position, know your projects, know your position, and the last one is set out your negotiation target. You have a very high expectation, but you have to realize what is your position now. What is position now to get your target or your purpose. And the most effective claim avoidance technique, if we are talking previously about the most common method, and this is a golden principle to negotiation. And the most effective claim avoidance, because we are talking about the dispute avoidance. First is risk management. Yeah, we have talked about the risk management in the beginning. The proper risk review process. You have to identify what is the tender document, how is the tender document appropriate, the validity of the tender document, and you address the what we call it, the clarification, deviation to the tender document. So you have to know from the very beginning. And the contract specification, contract and specification review, it should be taken by the specialists, by the professionals, which is understand and have a good experience and knowledge about this one. And the third party schedule review. So I think this is addressed to the what is the most common dispute and by Arcadis, because this research is also established by the Arcadis Global Construction Dispute in June. I think in June 2020. So I think this is very valid recommendation to what we call to mitigate the dispute in the very beginning stage. So it is my last slides. So what is the requirement expert and third party to avoid and mitigate the construction dispute? So first of all, maybe you have to appoint or you have to engage with the construction contract expert. Or in Indonesia, because in the Undang-Undang Jasa Konstruksi or the Indonesia Construction Law, there's some requirement of the ahli hukum kontrak konstruksi. It means that some pools of experts, from the expert of the procurement, expert from the law, a lawyer, and the expert from the technical from construction, which is give the opinion, or give opinion to the contract before the contract is signed. This is applicable for the contract which is above the 100 billion IDR, 100 miliar rupiah, 100 billion IDR must be reviewed by this so-called the ahli hukum kontrak konstruksi. So you have to see and you have to consider the risk from the review and before the contract was signed. And the second one is quantum expert. If you have to trying to submit your claim, the loss and expense and the disruption claims, you have to engage like Rohit and teams, which is very which can what we call assist you to to how to prepare and to present the claims. Delay analyst, yes, like Rohit. Quantity surveyor is some instance you have some dispute maybe in the very the end of the project, so-called like you have some dispute on the final account or final quantity stage. You have to engage the some professionals to judge or to help you to get the right estimation. So I think you have to engage some of the experts. And the forensic engineer, yes, I just told by my friends that Indonesia is a civil law, it is a civil law jurisdiction, and the Indonesia construction law is say that there is some requirement or provision of the the building failures, or kegagalan bangunan for about 10 years, So my one of my friend is appointed as a forensic engineer because one of the construction building or construction projects, the result of the construction project already handed over from the FAC, but according to Indonesia's construction law, 10 years after the FAC or the second handover, the final handover, there should be 10 years of like liability from the contractor to keep the building on the object of the construction project is well functional. So there is some claim for after the, let's say 3 or 4 years after the operation of the such buildings, then these forensic engineers will help you, to get what is the failures from the building or the object of the construction project. And also the dispute avoidance experts, is quite rare, but maybe you can appoint also with some recognized and experienced lawyers to what we call it to help you, to help you to avoid the dispute. Yeah. And if we are referring to the FIDICs, yeah, the dispute avoidance board, the dispute avoidance and adjudication boards actually is like a pool of not pool, but it's the expert from the actually these engineers, which has a good law background as well, to advise you, to give some advice to mitigate the dispute or the potential dispute at the very beginning of the project. So I think it's the last of my presentation, and maybe we can go to the interactive session by the Q&A. Mbak Lisa, the floor is yours. Thank you.
Okay, thank you, Pak Andi. We still have 1 minute, but I think it's better for us to continue to Q&A session. Okay, Pak? Okay, so for Q&A session, I have one question from Pak Agus Setiawan on direct message. It's in Bahasa, so I will help to translate the questions.
Okay, I think there is lost connection in Lisa, so maybe we can answer another question while waiting for Lisa to get back again. There is the question from Rakesh Srivastava. What is the best method to deal with claims arising out of disclaimer clause? Maybe Mr. Rohit or...
I think Mr. Dendi, you can answer,
Okay.
or if you explain me what exactly is the disclaimer clause which is being talked about.
Yeah, I assume that the disclaimer clause is on the condition of the site which will be handed over by the project owner to the contractor on as-is basis. Yeah. So under that situation, I know that it's very common, but under that the circumstances, I think we have to consider what would be the risk. And I think the most sensible approach to anticipate is in the contract forming stage. Yeah. So transferring or passing the risk to other parties. Yeah. For example, for the soil test, yeah, instead of doing it in-house, so the contractor may try to appoint external consultant to do the soil test. So, and any penalty that could be possibly demanded because of the mistake in doing the soil test. Yeah, for example, after the project is started, so the soil condition is different with what described in the soil test result, then the penalty related to that things will be absorbed by the company providing the soil test services. But also we have to note that under the Indonesian law, there is a clause in the Indonesian Civil Code, hidden defect. Yeah. So if the contractor can prove that there is a hidden defect on the site, which is known already to the project owner before handing it over to the contractor, but the project owner chooses not to disclose to the contractor, yeah, the hidden defect. So I think the contractor has a ground and may argue that it should be the default by the project owner. So I think that's my answer to the questions from Rakesh. Maybe Pak Rohit and Pak Andi, if you want to add something.
No, I think what you said is right. Generally in typical construction law, disclaimer clauses, also called as exception clauses, are dealt in a different fashion from one jurisdiction to another. Like what you called about the soil data, the soil data given is not matching with the actuals. We call that as unforeseen condition, ground conditions claim, which is very, very common in all jurisdictions, including Indonesia. So it depends upon what are the local laws and how they are going to be dealt. For example, the way this claim is going to be dealt in Indonesia will be different the way it is going to be dealt in London and in UK. So I agree to what Dendi said.
Are there any questions? Any more questions for the participant?
first question for the subcontractors, yeah? The termination of the subcontractors, which is
Oh,
the
Hello,
Yeah, maybe
Kandi.
Lisa, you can repeat that question related to the subcontractor payment. You were explaining, then you got disconnected. So if you can repeat that again.
okay. So basically, it's about subcontractor that would deny or cannot start to the contract performance due to the main contractor won't pay for the payment. So it would affect to the quality and time manner of the contractor, and how to deal with such conflict if the subcontractor won't start the work. I think basically the question would be like that.
So from my perspective, there are, it depends upon the terms and conditions of the contract. There is the FIDIC contract terms and conditions. At times, the old FIDIC contract had a clause wherein a contractor cannot slow down his progress, or a subcontractor cannot slow down his progress, even though if the payment has been delayed or has not been paid by the main contractor, it has the right to suspend the work after certain number of days. There are some other terms and conditions wherein, under the local jurisdiction, I'm not sure how Indonesian law deals with that, but there is a reciprocal obligation that if a subcontractor has to work, he has to get payment on time from the main contractor. Now, if the main contractor does not give payment on time, the subcontractor definitely is going to be affected, and his work is going to be delayed and disrupted. So it varies based on the terms and conditions of the contract and the local jurisdictions and the local laws, which probably Dendi and ND can further brief upon.
okay, Bu Malisa. Just in addition to Pak Rohit said that okay, this is very common and very happening now in this COVID situation in the Indonesia construction industry. That me also as a vendor or subcontractors has suspended the payment or just reschedule the payment to the next year if when there is some indication of the default payment by the employer. Yes, in this Indonesia, so many case happen right now in Indonesia. Then okay, the recommendation from Pak Rohit is very appropriate that you have to firstly you have to see the contract whether I don't know we got Pak Agustiawan whether your contract is FIDIC contracts or not, but you have to know about the clause of your first is the clause of suspension. Yeah. What is the entitlement of the maybe the contract subcontractor to suspend the works if for the contractor default. It is written in the contracts or not? Yeah, because I think in the very common what we call it the construction contracts in Indonesia is not allowing the subcontractors or the contractors which we are talking about with employers to suspend the works, but just the one side there. So the employer can suspend the work, but maybe the contractor cannot suspend the work. So firstly, you have to see what is the condition of your contract, what is the clause in the contracts, yeah. And the second one, you see that your question is the what we call it the pay the payment, yeah, the payment itself. So what is the regime of the payment? So is it a back to back? Because I think most of the Indonesia, I think like state owned, yeah, you know the habituation of the behavior of the state owned. Sorry, I just name the state owned contractors that they are trying to apply it as full as much as possible for the as a back to back payment. So I think and maybe taking some longer duration to take the payment. So I think firstly you have to see the what is the suspension clause in your contracts, and secondly you have to say what is the payment regime in your contract, whether it is a back to back, paid if paid, or paid when paid, or some what we call some terms, maybe some I don't know. You have to some grace period. Maybe you have to see what is the clause, and you if you are entitled to do the like a suspension or to suspend the work. So maybe you by contractually you have the rights, yeah, to do the one. And for the jurisdiction, maybe I think Dendi can explain well about what is the entitlement for the subcontractors, or maybe in these cases maybe creditor ya, Pak Dendi ya, to do the suspension in the event of the customer default. Yeah. In this instance, the payment default. Yeah. Pak Dendi, maybe you can add some things. Yeah.
Yeah, I think I agree on all the things that Pak Rohit and Pak Andy already explained. The only thing that I need to add is if there is no back-to-back clause in the subcontractor agreement with the main contractors, I think it's a bit tricky whether the subcontractor can postpone or delay any performance of its obligations under the subcontractor agreement. But again, if we see the most of the thing, the relationship, the law relationship is not directly to the project owner. Yeah. So the legal relationship, most of the case is between the subcontractor and the main contractor. So I think any delay or for whatever reasons by the subcontractor is not stopping the project owner to make any claim for any delay, for example, if there is something happen for these things. And that's point number one. Point number two, on the payment suspensions, I think it's not that easy actually to prove that the payment on the terms of the construction dispute can be categorized as a payment suspension under the payment suspension law, because under the payment suspension law, under the Indonesian bankruptcy law, the debt, yeah, it must be very simple and straightforward. So if immediately the main contractor argue that the payment is not due or the payment is totally due, it cannot be brought to the payment suspension mechanism, Andy.
Okay, Pak.
Okay, so are there any questions from the participant?
There are some questions in the chat box. Maybe you can read it. From Krishna Budiawan.
My question box is empty in here.
Okay.
Can you help me? Can you
Okay,
help me
I'll
to
help
read
you.
the questions?
Okay, so the question is for Mr. Rohit. Knowing the differences of delay analysis between retrospective versus prospective, what are those pros and cons and what the most suitable in Indonesia? As, correct me if this is not correct, certain court in Indonesia most likely will not agree with prospective method. Thank you.
Yeah. Mr. Krishna is right that in majority of circumstances, the courts and arbitrators do not agree to prospective method of analysis. So generally, the prospective method of analysis is submitted by a contractor only during its extension of time submission within the project execution duration. So when the project is ongoing, once the project is finished, and if the dispute has gone to courts and arbitrators, then they should not, then prospective method is not the right method, because generally the dispute goes to the court once the project is finished. So you know what is in actual has happened. You know, a prospective method does not deal precisely with the actual situation. It deals more on a theoretical basis, while a retrospective method deals precisely with the actual delays which have taken place in the project. Number one. Number two, both have their pros and cons. So for example, if a contractor submits the extension of time based on a prospective method of analysis, he will be entitled to a higher number of days of extension of time and cost as compared to a retrospective method of analysis. Why? Because in retrospective method of analysis, contractors' own delays are also taken into consideration, while in a prospective method of analysis, which is future looking analysis, you are not able to know or find out that in future what will happen, whether there will be more delays from the contractor or employer. So to sum it up, my presentation shows what are the pros and cons of each type, but definitely one suggestion and advice If you are intending to take your delays dispute to the court, don't use prospective method, use retrospective method of analysis.
Okay, thank you, Pak Rohit. And
Thank
the
you, Pak Rohit.
last,
Thank
for
you.
the last question would be to questions to Pak Andi. Dispute avoidance board. The cost of dispute avoidance board shall be to owner or contractor account.
Okay, but sorry. So the question from Pak Krishna is pointed to the FIDIX rules, yeah. So the AAB in the 2017 is the so-called dispute adjudication and avoidance board, yeah, DAAB, not a dispute adjudication.
Okay.
The cost, I think this is the same question that raised to me during my presentation when there's some event from the LKB, from the Indonesia Procurement Agency, that the cost should be at the very beginning should be shared by the owner and contractors. And you know that Indonesia has established the BADAPSKI, yeah. BADAPSKI is the Dispute Adjudication Board of Indonesia, which is regulated by law, by the latest construction law, that the cost or the involvement of the such BADAPSKI is can be as an option to for a forum of dispute resolutions at the very beginning of the project. So I think the cost is, yeah, ideally is to be shared by the owner and contractors, and because this is ranging from I don't know, yeah, in Singapore or in others, but it's maybe ranging about the 5 per mils until 0.005% from the construction cost, and it's a retainer basis, yeah. So I think this is quite a problem, yeah, in the beginning, because we are not really familiar with this kind of the BADAPSKI or this adjudication board that we have to spend. We have to expand at the very beginning for the appointment of the adjudication board. But it is very recommended, and it is very helpful for us as a construction industry practitioner to resolve the dispute from the beginning. So I think the ideal way is to share the cost and to include in the project cost, actually, as mandated by the Indonesia Construction Law number 2017 in the BADAPSKI as one of the option of the forum of dispute resolution. So Pak Krishna, maybe you can see again in the Undang-Undang Jasa Konstruksi number 2017, and how is the portion of the appointment of dispute boards. But as the spirit of this webinar, that the appointment of such what we call it the expert is very critical and very important, yeah, to minimize the delay, and also it is part of the risk of management process. Yeah, Krishna, I think hope that is answering your question. Krishna, thank you. Yeah.
Can I talk? Sorry.
Please,
Yes, go ahead.
Sorry, actually my question, it was related to if this is need to be shared between the owners and the contractors. So meaning to say that if we're referring to the PTK 007, which is coming to the open tender, so meaning to say that during the RFQ, from the owner to all the contractors, on all to the bidders, so that kind of the requirement should be in the requirement of the ITB. So then the contractor also should be bid based on that requirement, because they want involving some cost, yeah. So I mean, that kind of requirement should be there. So then it's not like suddenly all these kind of requirements come to the picture on the post-award, yeah. That's actually my point, Pak.
Yeah, Pak Krishna, I think you are coming from the oil and gas industry. You are referring the PTK 007 is the procurement guideline from the oil and gas industry. And I'm talking about the construction, actually, which is referring to the Undang-Undang nomor 2 number 2 2017 of construction services, Pak. So I think in the PTK, yes, PTK will, because you are dealing with the cost recovery to the Indonesia government's owners, and suppose you are working to the PSC or the what we call it the KKKS, yeah. So it must be written in the tender document. Agree with you, yeah. But then the authority of the what we call it the oil and gas is under the SKK Migas, yeah, under the provision of the PTK 007. So I think if it is what we call it, it is regulated in such a tender document, yes, maybe it can be applied. But you maybe as a procurement committee, you can, because this related with the cost, yeah, Pak, cost, and this related to the cost recovery to the government. So you have to consider from the beginning and in your tender document for the oil and gas project, Pak Krishna Budiawan.
Thank you, Pak Andi.
Okay, I think that would be the last questions for this session. Yeah, I think should be the end of our webinar session. Thank you everyone for your time in this webinar. We have gained a lot of insightful knowledge related to construction dispute risk. And also thank you for the speakers, Mr. Rohit, Pak Andi, Pak Dendi, thank you for your time. And also thank you for everyone as a participant. On behalf of ADCO, I would like to say thank you, and I hope we will meet again on the next webinar. Okay, thank you, and
Thank you.
have a great day.
Thank you. Thanks a lot. Thanks everyone.
Thank you. Thanks everyone.